Friends, a living will or an advance medical directive is written instructions regarding the preferences for medical treatment if one is unable or incapacitated from making such decisions. An AMD or an advance medical directive usually spells out the medical treatments that one would want or not want to keep oneself alive. Now, this AMD also nominates or empowers another person to make such decisions should you be unconscious or unable to make these decisions yourself. That is by and far the meaning of a living will or an advance medical directive. Now, friends, I am not here to convince you either about the urgency or the necessity of having a living will. That would be far too presumptuous of me to do so. But I do feel that this life and death subject is one which we have avoided discussing for far too long. So I am here only to give my perspective. I am here to urge you to think about this subject and someday make a conscious decision, whatever that decision might be. I believe that there are no passengers on this spaceship Earth. We are all the crew. We are all the drivers, and therefore let us not surrender our driver's seat. I have a confession to make, and I think I should quote Abraham Lincoln, who was known very rarely to give any long speeches or write any long letters. But once he wrote a very long letter to his friend in a very minuscule handwriting, and he ended it by an apology that he did not have the time to contemplate, correct, or edit his letter, and that is why it has become so long. I find myself somewhat in the similar predicament today. I came back from Bombay with a lot of work, and I could not devote much time for this presentation. So in anticipation, I ask your forgiveness. I will try not to go on too long, but if I do go overboard and far exceed my allotted time, Mr. President, please accept my advance judicial directives to pull off the plug of this microphone. Mind you, silencing a judge who talks too much is not contempt of court, but in fact it is social service. Mahatma Gandhi once said, and he advised us, that we should live as if we were to die tomorrow and learn as if we were to live for an eternity. Unfortunately, we tend to reverse the sequence and feel nothing about postponing matters. As judges and lawyers, we have acquired the notoriety for postponing practically everything. But it can be different with doctors. Generally, as patients, we rely on their skill to postpone reaching the destination from which no traveler ever returns. But today we want to discuss how good such postponements are once we reach a point of no return, and pointless pain and suffering are the only companions until the final destination is ultimately reached. As sensations diminish in intensity, the sense of vitality usually fades. The desire for life gives way to indifference and patient waiting. The fear of death is then strangely mingled with a longing for a repose. It is in this twilight zone of to be or not to be that becomes the Hamletian question. Doctors, as we know, are trained to keep their patients alive as long as possible. Their Hippocratic oath binds them. The Hippocratic oath says that I will not give a lethal drug to anyone if I am asked, nor will I advise such a plan. Therefore, perhaps not many doctors explain or discuss to prepare people or how to prepare people to die gracefully or to die with dignity. And yet for many patients, mainly the old and the terminally ill, death is most often a question of when and not if. Therefore, should medical profession not rethink of its approach to such life and death issues? And if so, in what way? And if the medical profession is prepared to rethink its approach, are we all geared up to support it? Is our present state of law equipped to deal with such issues? Are there any judicially or socially manageable standards to effectively address these issues? Is it not high time that we speak, deliberate, debate on this all-important subject? Is it not high time that the legislature steps in and gives us some legislative guidance? Friends, philosophical questions apart, actual practicalities call for meaningful discourses and discussions if some broadly acceptable solutions could be found. These questions have become increasingly relevant with aging populations, nuclear families, focus on dignified living and not merely survival, and medical innovations that inevitably come with spiraling hospital costs. Permit me, therefore, to touch on some basic concepts associated with today's topic. Friends, you have all heard about euthanasia. Euthanasia means intentional premature termination of life of another person at her request and to cause her good death. Active euthanasia means death of a person with her consent by direct medical intervention. Some positive act on part of the person causing the death is necessary. Passive euthanasia means withdrawing or withholding life-prolonging medical treatment following the express or implied will of the terminally ill, or the brain dead, or patients who are in a permanent vegetative state. It will result in her death. So therefore, basically, active euthanasia requires maybe to inject a lethal drug or something of that kind. Whereas a passive euthanasia would mean you stop the life-giving support. You don't give any additional treatment so that the patient's life is unnecessarily prolonged. Now, voluntary euthanasia means terminating the life at the request of the patient. The request may be made either before contracting the illness or even during the illness if the patient is in a state 2. Non-voluntary euthanasia means terminating the patient's life without the patient's consent. This usually arises when the patient is not in a position to give his or her consent. This may be for the patient's good on a proxy request where the patient cannot express her views. But this is entirely different from an involuntary euthanasia, which means terminating the life against the patient's will. This is not permissible at all. There has to be either an express or an implied consent, or if the patient himself cannot give the consent, some proxy, assuming responsibility, will have to give the consent. But there cannot be any involuntary euthanasia. God forbid, but unfortunately, this scene which I described is not uncommon. You rush a near and dear patient to the hospital. The doctors try their best. The prognosis is not at all good. The vital parameters are fading. True to their Hippocratic oath, the doctors transfer the patient's fate to a ventilator. All kinds of tubes are employed to enable the patient to breathe, eat, excrete, and so on. The doctors admit that medical science has nothing further to offer, and they have no answers as to how long this would continue. The doctors say that they cannot stop the treatment or withdraw the ventilator or tubes, mainly due to medico-legal or even ethical reasons. You do not know what to do or what decision to make. Your sentiments and emotions invariably cloud your judgment. You hope against hope and you pray for miracles. You are unsure whether all these ventilators and invasive tubes are causing acute distress to the patient you love and you care for so much. Still you hesitate. You think about what others might think. You develop acute guilt for failing someone who may have cared for you when you were small and most vulnerable. It may appear crude, but mounting hospital costs can pose genuine difficulties. The ICU charges could be astronomical, particularly when the rising futility hits you hard. As if this onslaught of myriad sentiments was not enough, you genuinely do not know what is legally permissible and what is not. If a patient is in a state to inform the doctors to stop the treatment, can we say that a point of no return has already been reached? If a patient pulls off the tubes, will this amount to suicide? Will you be guilty of abetting suicide? If on the patient's directives the doctors pull off the tubes, would it amount to active euthanasia, which in today's state of law is still not permissible? Do you have the authority to direct or stop treatment? Does such a direction bind the doctors? Now, all these situations and questions admit of no easy answers. These could be truly traumatic times. Now, would you ever like your near and dear ones to go through such trauma? Or would you consider all such matters now when you are in control of all your faculties? Not always do these traumatic situations come with forewarning or at least with sufficient forewarning. A living will or an advanced medical directive could be a substantial help. It is surely not foolproof, but it will be of substantial help. It would at least to a considerable extent spare them from this kind of avoidable trauma. It would spare them the trauma of making such life and death decisions about you. It would at least to some extent unburden them of very painful and traumatic responsibility, guilt, and even angst. All that I say to you today is that this is a subject on which you must think seriously, and not procrastinate. In the legal world, somehow this topic of active or passive euthanasia got linked with the subject of suicide or attempt to commit suicide. Section 309 of the Indian Penal Code, there is an equivalent section now in the new Penal Code, but Section 309 of the old Indian Penal Code provides that an attempt to commit suicide is an offence which is punishable with imprisonment for a term which may extend to 1 year, or with fine, or with both. Now let me illustrate about 3 or 4 cases, if you permit, which speak about the evolution of this law leading to permitting advanced medical directive or living will. Now Maruti Dubal was one of the earliest cases in 1986. Maruti Dubal was a police constable attached to the Bombay City Civil Force. In 1981, he met with a road accident and he suffered serious head injuries. In 1982, he was diagnosed with chronic schizophrenia. He suffered from auditory and visual hallucinations. He was given electric shock treatment, which was the treatment those days, and constantly flooded with a heavy dose of tranquilizers. On 27th of April 1985, Maruti went to the Municipal Commissioner's office at Bombay with a recommendation from a minister seeking a license for his wife to sell some vegetables on the street. His wife's application was apparently pending for over a year. The security guard would just not let him in and meet the commissioner of the municipality. Under extreme stress and frustration, Maruti rushed out of the commissioner's office, snatched some kerosene from a roadside vendor, poured it on himself, and tried to set himself on fire. He was arrested and prosecuted for the offence of attempting to commit suicide, which was punishable under Section 309 of IPC, and it could extend to imprisonment for about a year. Now, Maruti challenged the constitutional validity of Section 309 as violative of Article 14, which deals with non-arbitrariness and equality, and Article 21, which deals with right to life. Right to life has been interpreted to mean a dignified life. The Bombay High Court struck down Section 309 of IPC, reasoning that right to live, guaranteed by Article 21, also includes its negative, that is, the right not to live. The court also found the provision to be arbitrary and violative of Article 14 on the ground that a person who attempts to commit suicide needs some medical time and not jail time. This was in 1986. In 1994, in Ratinam's case, a division bench of the Supreme Court actually upheld his decision and said that yes, this is correct. Right to life includes right not to live or the right to die. So at least up to 1994 or at least in 1994, the law was that an attempt to commit suicide is no longer a crime. But this position did not continue too long. This position changed in 1996. There was another provision in the IPC, that is section 306 of IPC, which criminalized abatement to suicide. Now you hear in the newspapers a lot of stories about somebody committing a suicide, leaving a suicide note, saying that it is because of this person that I was forced to commit a suicide. Now that is called as abatement to suicide, and that is a very serious offense. Section 306 says that if you are convicted, you could suffer imprisonment up to 10 years and fine, and of course both. So, Gyan Kaur and her husband Harbans Singh were accused of aiding and abetting suicide of their daughter-in-law, Kulwant Kaur, since they wanted their son to marry someone else who would bring them perhaps a greater dowry. They were tried, convicted and sentenced to rigorous imprisonment of 7 years by the Sessions Court. The High Court reduced Gyan Kaur's sentence to 3 years but maintained the husband's sentence to 7 years. Now Gyan Kaur and her husband challenged their conviction and also the constitutional validity of section 309 of IPC. And relying upon Maruti and Ratinam's cases, they argued, their argument was very simple. They said that if attempt to commit suicide is no longer a crime, then abatement to something which is not a crime, how can that be a crime? And this was a legal jinx, and the Supreme Court found it very difficult to answer this question. So in fact, in this case, they appointed senior advocate Fali Nariman and Soli Sorabji, one of the two most eminent lawyers of our country, as amicus curiae, which means the friend of the court, to assist them to sort out this kind of a question which was raised. The Supreme Court ultimately overruled P. Ratinam and Maruti Dubal, and they disapproved the relatively broad proposition about the right to life, including the right to die, as an absolute right. However, the Supreme Court held that right to life includes the right to live with human dignity, and this will include the right to live with dignity up to the very end of the natural life. The Supreme Court also said that this includes a dignified procedure for death. In other words, right to life may include the right of a dying man to die with dignity when his life is ebbing out. Now, in conclusion, the Supreme Court also clarified that the debate to permit physician-assisted termination of life, they said we are not deciding it, we only hold that up to now it is inconclusive. So from 1996 onwards, attempt to commit suicide was restored as a crime, but a small window of doubt was opened by the Supreme Court regarding physician-assisted termination of life. Now in 2011, the Supreme Court once again revisited these issues in the famous case of Aruna Shanbhag. Aruna was a junior nurse working in the KEM hospital at Bombay. In 1973, she was sexually assaulted by a janitor, and she remained in a permanent vegetative state for almost 40 years after this brutal assault. A journalist, Pinky Virani, petitioned the Supreme Court, claiming to be her next friend, to direct the hospital to stop feeding her and allow her to die peacefully. In short, the prayer was, permit euthanasia. The doctors and the staff of KEM intervened in the matter, and they strongly opposed the petition, saying that Aruna was not a burden on them and that it was their honor to take care of her. They said that it was our privilege to take care of her. The court ordered a committee of doctors to examine Aruna. The court considered the affidavits of the dean and staff members, and on facts, they dismissed the case. They said that in the facts of this case, we will not allow or we will not issue any direction to the hospital to withdraw life support to Aruna. and see that her life is ended. But the court held in this judgment that active euthanasia, which involves administration of a lethal dose to the patient, is a crime in the present state of legislation in India. But most importantly, the court held that non-voluntary passive euthanasia, which involves withdrawal of life-saving measures, is permissible, even without any supporting legislation, subject of course to certain conditions, safeguards and procedure, which the Supreme Court itself introduced in the said decision. So Aruna Shanbag's case is a landmark decision when it comes to this issue of euthanasia, and eventually it paved the way of the judgment in common cause, which gave a recognition to living wills. Now, in 2018, the decisions of P. Rathinam, Gyan Kaur, Aruna Shanbag were again evaluated by a constitution bench of the Supreme Court in the case of common cause. Common cause is an NGO which takes up public interest issues, and a constitution bench of the Supreme Court is a bench comprising of not less than 5 judges. So this was an important subject. That is how they took it up. The constitution bench acknowledged that the subject of active or passive euthanasia or advanced medical directives should be best addressed by the legislature, either by the parliament or the state legislatures. However, in the absence of any legislation, they said that these topics were far too important to be left in a state of a limbo. Accordingly, the Constitution bench, by invoking, among other things, their powers under Article 142 of the Constitution, declared that voluntary and non-voluntary passive euthanasia was permissible in India, again subject to certain specific terms, conditions and safeguards. The Constitution bench held that passive but not active euthanasia could be permitted for patients who are terminally ill, in a permanent vegetative state, or brain dead without any hope for revival. The court ruled voluntary and even non-voluntary passive euthanasia is permissible. Further, perhaps for the first time, the court held that adults in their conscious mind can also execute a living will through advanced medical directives, directing the doctors and relatives not to prolong their lives by pointless medical treatment. On an application filed by Indian Society of Critical Care Medicine, certain changes were made in this order. Now, broadly, if you permit, the scheme spelled out by these decisions is this: and an AMD or a living will could be executed only by an adult who is of sound mind, in a healthy state of mind, and in a position to communicate, relate, and comprehend the purpose and consequences of executing such a document. Now, an AMD must be executed with the presence of at least 2 attesting witnesses, preferably independent, or before a notary public. Notary public or even any other gazetted officer. It need not be only a notary public. The witnesses and the notary or the gazetted officer must record their satisfaction that the document has been executed voluntarily, without coercion, inducement or compulsion, and with a complete understanding of all relevant information and consequences. See, these are only safeguards. So if you are executing it before a notary or a gazetted officer or witnesses, they have to also record that we have seen this person, he has signed before us, we find him to be fine. So basically this is voluntary. It's not that somebody is forcing this person to sign the will. Now the AMD or the living will should have the characteristics of an informed consent. It must be clear, unambiguous and stated as revocable. One thing about the living will is that you can make as many living wills as you want. The last will prevail, and you can, though the will is made in writing, you can even revoke it orally in front of a doctor or in front of a witness. So it is not as if once you have made the will, you can never retract from it. Ultimately, dear friends, democracy is based on giving the competent adults access to all relevant information on a subject and then trusting their ability to decide for themselves. And friends, I thank today's distinguished audience for bearing up with me for all this while. Thank you very much and Jai Hind.